not just what was in this hearing today, but anything that you heard in the trial itself. You heard from a few witnesses today talk about Megan's childhood. You're going to get jury instructions on mitigating factors that the defense would like for you to consider. Things like how old Megan Boswell was at the time, Megan Boswell's childhood, the things that she witnessed, role models in her life, etc. But I submit to you that there are a lot of people who have hard childhoods. There are a lot of people who have babies when they're young, and those people do not kill their children. Those people do not wrap their children in blankets and foil and put them in a trash can upside down. When you look at these mitigating factors, and it looks like they have submitted 11 mitigating factors, I submit to you that lots of people have childhoods like the defendant had. But you heard from her own grandmother that her grandmother and grandfather were stability for her. And I submit to you that just because you have the childhood that you have, and of course we all, you included, have different life experiences, that does not make an excuse for what she did to Evelyn. The defense is telling you that Megan Boswell deserves life with the possibility of parole, which is essentially roughly 51 years in this state, which would mean that Megan Boswell could get out in her late 60s, I believe. I submit to you that Megan Boswell she doesn't deserve that chance. Does Evelyn get the chance when she's 69 years old to start her life again? She doesn't. Neither does Megan. We are going to ask that you continue to hold her accountable. The state has proven the aggravating factor that Evelyn was under the age of 12 years old and that the defendant was over the age of 18. We have proven that. And that is all the state has to prove. And if you believe that the state has proven that beyond a reasonable doubt, we're going to ask that you return a verdict of life without the possibility of parole.
Thank you, John. Mr. Horn.
Ladies and gentlemen, I know the last few days have been emotional for you. It's been emotional for everyone. That emotion really began 5 years ago. Not just for this case, but for our community. And it has had some dividing and rippling effects. You've been sequestered, you haven't seen those things, but we have. We've seen how divided this community is over this case. Perhaps that could last and go on for a long time. You spoke very loud today in and you found Megan Boswell guilty. I think it's time that we end all of this on the right note. You have a chance to do that. I don't, state doesn't, the judge doesn't, you do. You can put the defining moment, the period of what people will remember about this case, and perhaps you as jurors, because you did find her guilty. And now you have a chance to do and show the one thing that's been missing for the last 5 years. That's grace and love. We have all, everybody in this room has failed in some way in their life. It may not have resulted in a criminal charge. It may not have resulted in going to prison. But we've done something. We've wanted compassion. We've wanted grace. We've wanted love. That's how you can end this. And that's how we can start to move on as a community. And you can show her what love looks like. Because you've heard how fractured and dysfunctional her family is. Mr. Scott told you in the trial, he didn't go through a lot of things in her life. I didn't either. But I knew my mom and dad loved me. They loved me to the end. My family now loves me to the end. I don't think she's seen what that looks like in her life. You're going to get a chance. Go back there and show her. You can tell her that she's redeemable. You can end it with grace and love. General Boswell told you about those mitigating factors. You'll get them in your jury instructions. Spare her life and give her life without parole. If there's anything good can come from this, is that we can all move forward, knowing that you got the verdict that you wanted, and you ended it with the emotion of love and compassion. That's what will be remembered. And I hope that's what you do. Don't be remembered for just compounding the tragedy and the tragedy and the tragedy. So easy to do that. The lasting impression that you give Evelyn, that you give Megan, that you give this community, is that love and grace can still be found through all of this. And we ask you to give her life and let her have a chance to come out one day. That's justice as well. Justice for everybody. Thank you.
Thank you. General.
Thank you, Judge. Ladies and gentlemen, your job at this point is to determine whether or not the state has proven the aggravated statutory aggravating factor that we alleged. And as General Massengill told you, that was simply related to the age of the child as well as the age of Ms. Boswell. And clearly through her birth certificate, we have proven that aggravating factor. So then your job will be to weigh the mitigating factors that the defense has put on for you against that aggravating factor, which we have met our burden of proving. Mr. Horns asked you to end this case on the right note, and they would agree. You should end this case on the right note, and you should show Megan Boswell the same compassion and grace that she showed Evelyn. Evelyn wasn't shown any compassion. She wasn't shown any grace. You know, the one person that Evelyn should have been able to rely on to protect her, to keep her safe, abandoned her, discarded her. She doesn't deserve your compassion, your grace. The state asks that you weigh the aggravating factor that we've proven in this case, the fact that Evelyn Boswell, at the time she was dumped in a trash can, wasn't even 13 months old. Never had a chance. We ask that you return a verdict we've requested of life without parole.
All right. Thank you, General. Okay, ladies and gentlemen, I've got another set of instructions I've got to read to you. In the criminal court for Sullivan County, Tennessee at Bonneville, State of Tennessee versus Megan Boswell, defendant. Case S72869. Jury instructions. Fixing punishment of life imprisonment or life imprisonment without the possibility of parole. Members of the jury, you have now found the defendant guilty beyond a reasonable doubt of first-degree murder in the perpetration of a first-degree murder as charged in the first count, and first-degree murder in the perpetration of a felony as charged in the second and third counts of presentment number S72869. It is now your duty to determine, within the limits prescribed by law, the penalty which shall be imposed as punishment for these offenses. Tennessee law provides that a person convicted of first-degree murder and first-degree murder in the perpetration of a felony shall be punished by imprisonment for life without possibility of parole or by imprisonment for life. A defendant who receives a sentence of imprisonment for life shall not be eligible for release until the defendant has served at least 51 full calendar years of such sentence. A defendant who receives a sentence of imprisonment for life without parole shall never be eligible for release. In arriving at this determination, you are authorized to weigh and consider any of the statutory aggravating circumstances proved beyond a reasonable doubt, and any mitigating circumstances which may have been risen by the evidence throughout the entire course of this trial, including the guilt-finding phase or sentencing phase or both. The jury is the sole judge of the facts and of the law as it applies to the facts in this case. In arriving at your verdict, you are to consider the law in connection with the facts, but the court is the proper source from which you are to get the law. In other words, you are the judges of the law as well as the facts under the direction of the court. The burden of proof is upon the state to prove any statutory aggravating circumstance or circumstances beyond a reasonable doubt. Reasonable doubt is that doubt created by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of your verdict. Absolute certainty is not demanded by law, but moral certainty is required, and this certainty is required as to every element of proof necessary to constitute the verdict. The law makes you, the jury, the sole and exclusive judges of the credibility of the witnesses and the weight to be given to the evidence. The defendant has not taken the stand to testify as a witness during the sentencing hearing, but you shall place no significance on this fact. The burden is on the state to prove any aggravating circumstance or circumstances beyond a reasonable doubt. She is not required to take the stand in her own behalf, and her election not to do so cannot be considered for any purpose against her, nor can any inference be drawn from such fact. Statutory aggravating circumstances. Tennessee law provides that no sentence of imprisonment for life without possibility of parole shall be imposed by a jury, but upon a unanimous finding that the state has proven beyond a reasonable doubt the existence of one or more of the statutory aggravating circumstances, which shall be limited to the following. 1. The murder was committed against a person less than 12 years of age, and the defendant was 18 years of age or older. TCA 39-13-204I. 1. Members of the jury, the court has read to you the aggravating circumstance which the law requires you to consider if you find proved beyond a reasonable doubt. You shall not consider any other facts or circumstances as an aggravating circumstance in deciding whether imprisonment for life without possibility of parole would be the appropriate punishment in this case. Mitigating circumstances. Tennessee law provides that in arriving at the punishment, the jury shall consider, as previously indicated, any mitigating circumstances raised by the evidence which shall include, but are not limited to, the following. 1, the defendant has no significant history of prior criminal activity. 2, the youth or advanced age of the defendant at the time of the crime. 3, the defendant experienced an unstable and chaotic home life as a small child and teenager. 4, the defendant witnessed domestic violence and physical altercation between her parents in the home. 5, the defendant witnessed her parents participate in drug use and abuse as a child and teenager. 6, the defendant experienced numerous school transfers during her academic career. 7, the defendant's primary positive role model and protector died when she was 12 years of age or 12 years old. 8, the defendant had only limited access to positive family influences throughout her life. 10, the defendant participated as a caregiver to her handicapped brother and younger sister. 11, any other mitigating factor which is raised by the evidence produced by either the prosecution or defense at either the guilt or sentencing hearing. That is, you shall consider any aspect of the defendant's character or record or any aspect of the circumstances of the offense favorable to the defendant which is supported by the evidence. The defendant does not have the burden of proving a mitigating circumstance. There is no requirement of jury unanimity as to any particular mitigating circumstance or that you agree on the same mitigating circumstance. Verdict: life imprisonment or life imprisonment without possibility of parole. If you do not unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, the sentence shall be life imprisonment. You will write your verdict upon the enclosed form attached hereto and made part of this charge. The verdict shall be as follows. We, the jury, unanimously find that the punishment shall be life imprisonment. If you unanimously determine that a statutory aggravating circumstance has been proved by the state beyond a reasonable doubt, you shall, in your considered discretion, sentence the defendant either to imprisonment for life without possibility of parole or to imprisonment for life. In choosing between the sentences of imprisonment for life without possibility of parole and imprisonment for life, you shall weigh and consider the statutory aggravating circumstance proved by the state beyond a reasonable doubt and any mitigating circumstance or circumstances. In your verdict, you shall reduce to writing the statutory aggravating circumstance so found, and you shall return your verdict upon the enclosed form attached hereto and made part of this charge. The verdict should be as follows. We, the jury, unanimously find that the state has proven the following listed statutory aggravating circumstance or circumstances beyond a reasonable doubt. Here lists the statutory aggravating circumstance or circumstances found. You shall then indicate on the enclosed verdict form either we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or we, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. The verdict must be unanimous and signed by each juror. I've got verdict forms for you. Okay. I have verdict forms for you, and I will read those. Verdict form, count 1. Punishment of imprisonment for life. We, the jury, unanimously determine that no statutory aggravating circumstance has been proven by the state beyond a reasonable doubt. We, the jury, therefore find that the sentence shall be imprisonment for life. Signature line, jury foreperson, signature line for each juror to sign. A date with a line. Verdict form, count 1, continue. Punishment of imprisonment for life without the possibility of parole or imprisonment for life. We, the jury, unanimously find the state has proven the following statutory aggravating circumstance or circumstances beyond a reasonable doubt. Check the box of any statutory aggravating circumstance or circumstances you find beyond a reasonable doubt. Checkbox. The murder was committed against a person less than 12 years of age and the defendant was 18 years of age or older. Below, check one box only. Checkbox. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life without possibility of parole, or checkbox. We, the jury, unanimously agree that the defendant shall be sentenced to imprisonment for life. Signature line, jury foreperson, signature line for each juror. Date, signature, blank. And the same exact form verbatim for counts 2 and count 3. take the case, consider all the evidence fairly and impartially, complete one of the 2 forms for each count, and report your verdict to the court. All right. Go with the officers.
Everyone stand, please. You may be seated. Thank you.
All right, jury's out at 12:09 p.m. to consider sentencing. This court will be in recess, waiting the verdict of the jury.
Court stands in recess.